Okay. All right, you know what? I'm going to kick us off. I know we'll have more people joining, but out of respect for everyone's time, I'm going to get started. So, welcome everyone. My name is Renee LeBron. I'm co-founder of Women Founders Network, along with Daria Alanatar, who many of you know. And I have the honor of being the host for today. And we are grateful to Alexis Steinberg, who is with Greenberg Glusker Law Firm, and she's going to give the talk for today. And just to give you a little bit of background, so Alexa is a corporate and transaction counsel for middle market companies and entrepreneurs at Greenberg Glusker. But she also acts as outside general counsel. So for those of you who are just starting companies, you probably know you're too small to have a general counsel, but it's handy to have someone who can act in that capacity and attend your board meetings and do some of that just sort of general legal work. So she does that for companies in addition to her focus on mergers and acquisitions, which hopefully you will all need down the future when your companies are big and successful. So you can read her full bio, but she takes a very personalized approach to client representation and priding herself on being attentive and being an integral part of her client's team, which is always super important. Hey, for those, something just came up on recording. If you could turn off your personal recordings. We do have a recording of the session, but we try not to use other recordings, please. And by the way, this will be available on our website, the recording of this. So before I turn it over to Alexa, a few things I want to remind you. May 31st is the upcoming deadline for our fast pitch competition this year. The link should be here in the chat. Yep, there it is. Feel free to apply. Remember, we have two tracks, the consumer track and the tech track. And the winners, we give away $55,000 in cash prizes. And you also, all the finalists have a financial coach, a pitch coach, and some other services that our in-kind sponsors provide. My other announcement is that we have another upcoming webinar. The next one of the series is May 22nd, which is on cap table basics, something that manages to confuse everybody. So I recommend that as well. And I mentioned this was recording. So question, what if you fit in both tech and consumer? If you're not sure, I suggest you send Kim an email, describe your business, and we will make a decision as to which one we think you're most appropriate for. It's a lot harder to move it after the fact. So yeah, so reach out to Kim and it'll probably end up with me, and we will figure it out. So with that, Alexa, I'm going to turn it over to you. If you have questions, why don't we just use the chat for questions? And I will keep an eye on the questions, and at the end, kind of moderate the questions for Alexa so she doesn't have to be reading at the same time she's speaking.
I already have too many windows open.
I understand. All right, Alexa, take it away.
Well, hi, everybody. Thank you so much for the introduction. As Renee said, I'm Alexa Steinberg. I am outside GC and M&A counsel at Greenberg Glusker in Century City. I serve my clients middle market, a lot of family-owned, closely held entities. And I'm excited to talk to you today about term sheets and operating agreements, two things that are sort of the vital foundation of any successful business. You need to have an understanding of what your business agreements are, and you've got to memorialize them appropriately. And term sheets and operating agreements start as the foundation of building your successful business. So that's what we're going to talk about today. I'm going to go ahead and share my screen and my slides. These slides will be available tomorrow as a PDF. So don't worry about trying to take pictures of them or take notes, this is being recorded. You'll also get a copy of the PDF sheets as well. So if I can figure out which screen I'm going to share. Okay. Is everyone seeing my screen? I can't tell which one is being shared.
I see it.
Is my mouse moving in it?
Yes.
Okay. So I'm sharing the right screen. Thank you, Renee. Okay. So term sheets and operating agreements. We had an introduction. I'm Alexa. There's my email address. I can make it available in the chat later. You can also find me on LinkedIn or the Greenberg Glusker website if you need to contact me. If you have any follow-up questions, I'm happy to answer. So we've got a lot that we're going to cover, and we're going to go through these main sort of checkpoints and basics here. And of course, I could discuss the intricacies and the impact of each provision in these agreements until we're blue in the face. But I'm not going to do that today. I'm just going to give you this broad overview. And in the next hour, I'm going to arm you with tools so that you can do preliminary reviews of your own term sheets and operating agreements, know what you're reading, know what is supposed to be included in them, and educate you not only to the legalese that are in some of these agreements, but arm you with a strategy that can empower you in your negotiation of term sheets and your operating agreement. So our quick overview of our agenda, we'll start a discussion on term sheets, why a term sheet's a good idea, the contents of a term sheet, the non-binding nature of a term sheet, and some problems and solutions that I've seen in my practice. Then we'll move on to operating agreements. What is it? Why do you need one? Member versus manager managed LLCs, contents of an operating agreement, authority, distributions, and transfer of interest. So that's a broad overview about what we're going to talk about today. Term sheets. So here's a little executive summary and a few questions that we're going to answer. All major deals should start with a term sheet, whether it's a partnership agreement, a purchase agreement, a funding, a distribution agreement. You should all, the terms of these agreements should all be reduced to a term sheet. And the major characteristics of a term sheet are, the certain provisions that need to be included, the binding nature, and how can a term sheet be beneficial to your negotiation? So let's jump into it. What is a term sheet? A term sheet is a preliminary agreement that will be replaced with a final form agreement once all of the terms are agreed upon. It's a bridge between initial negotiations and a formal legal binding agreement. And it's supposed to be sort of this brief yet comprehensive overview of the fundamental aspects of your proposed transaction. It's really a summary of points, typically of business terms. There's usually some legal terms that'll be thrown in there: exclusivity, confidentiality, indemnification provisions. Those are sort of the statement boilerplate, if you will, legal terms that we like to include in term sheets. But really, a term sheet is supposed to memorialize the business agreement. What are you going to do with this other party? What kind of agreement are you entering into? How much is one party paying another? What are the parties' responsibilities? What are the parties' liabilities? What's the story about what these two parties are going to do together? And so that's really what we're laying out in the term sheet. It's the structure and the strategy of the deal. I'm going to do this. You're going to do that. I'll pay you X, Y, Z for X amount of time. That's really the meat and potatoes of what a term sheet is. And it'll be used as sort of your summary outline when you go to draft your full-fledged, formal, legally binding agreement. Which then poses a question. Why am I wasting my time summarizing an agreement that I'm just going to go spend money to have drafted? Why not just draft the agreement? Which is a very good question. And a lot of my clients will say to me, I don't need a term sheet. Let's just draft the agreement. Like, why are we wasting time? Why are we wasting money? You know, it's going to take X amount of days and it's going to cost X amount. And, you know, I just really want to jump to a formal legally binding agreement and just present it to them because I just want them to sign. And to my clients, I say, term sheets create momentum. So aside from sort of the general basics of a term sheet summarizing what your agreement is going to be, term sheets present an opportunity for these parties. It presents an opportunity to kickstart negotiations. Put your money where your mouth is. If you present, you know, an opportunity to a third party and say, listen, I want you to distribute my product for me. And I think this is how we're going to do it, you know, and you could sit and have conversations or email back and forth about it until you're blue in the face. But until you put your money where your mouth is and show the other party that you're serious, sometimes things just kind of drag on. So term sheets can do that. It shows that you are serious, that you've spent money and time thinking about what this relationship is going to be. And it shows to the other party that, you know, you really want to move forward, that this is something that you really want to do. And you've spent time and resources and energy in this. And that really starts to solidify negotiations. It lets the other side know that you're serious without having to throw good money after what potentially could be bad. Meaning, you're having conversations, you know, with a contracting party, and I want you to distribute my product for me, and this is what the agreement is going to be. If you spend what could be thousands of dollars drafting a full-fledged legally binding agreement and send it over to this contracting party and say, this is what I want to do, here's the agreement, it could backfire. It could be, you know, I don't think that we are on the same page here. I didn't see our relationship going this direction, or this is just not financially plausible. I can't pay for X, Y, Z. I can't give you exclusivity of distribution channels. You know, there are so many things that maybe hadn't, or you hadn't realized hadn't been worked out. A lot of terms that maybe neither of you realized were issues. And now you've spent thousands of dollars and a lot of time and a lot of energy drafting an agreement that is potentially a dead deal because you just weren't on the same page when you move forward. And so the nice thing about term sheets is they're a cheaper way, not inexpensive, but a cheaper way for you to be able to show a contracting party that you're serious, and not have to waste a lot of time and money on a full-fledged agreement that may not go somewhere. It allows parties to get on the same page and highlights potential undefined issues and undiscussed terms. It could be, you know, I want you to distribute exclusively my product, and I want it in this territory. And the contracting party could say, well, I have other products that I'm distributing in that territory already. And for you, the bread and butter of this agreement was access to that territory and being exclusive. And if you can't get that, you know, that should start or spark a conversation, a negotiation of what we can do to resolve that. And we can do it without going back and forth with a costly full-fledged agreement and making edits to a 5, 10, 15, 20 page agreement versus hammering out business issues in a term sheet where it's a one sentence, one liner that this is what the party is going to do. This is where they're going to distribute. So it allows you to get to where you want to go and presents you with the ability to have those discussions about terms you might not have thought about. You know, and enables the party to resolve these problems before really becoming emotionally, financially entrenched in the position that they're in. You don't want to fall in love with the house before you know if you can buy it or not. So that's really why term sheets are a great tool to use to just start off your negotiations, to make sure you and the contracting party are on the same page, to limit your financial exposure, your financial liability. You know, those are all great reasons that I say to my clients, let's start with a term sheet, just to make sure everybody has a meeting of the minds. We're all on the same page. Okay. So now that we've discussed why you should probably use a term sheet, what terms are we including in the term sheet? Now, term sheets can be the starting point for a lot of different agreements. They can be the starting point for a funding round. They can be the starting point for a purchase. They could be a starting point for the sale of equity. They could be the starting point of a distribution agreement, manufacturing agreement. Really, it runs the gamut. An employment agreement. You can use a term sheet for any of these things. Pardon me. And so what terms to include in a term sheet are going to vary based on what the final form definitive agreement is and what it looks like. But there are sort of these broad overview of what the terms are that you see in most term sheets. These are the big sort of general ones. What's the agreement about? Who are the parties? What are responsibilities being created for each party? So what's my name? Am I contracting in my individual name? Am I contracting in the name of my company? Who are you contracting as? What are we doing? Are we creating a partnership? Are we creating a licensing agreement? Am I allowing you to, am I hiring you to distribute something? Am I hiring you as a consultant for my business? What is our relationship going to be, and what responsibilities are going to be set forth between each party? The legal transaction structure. What is the definitive agreement that's going to come out of this term sheet? And what's the process look like? So, you know, for example, you know, Alexa and Renee are going to enter into an employment agreement whereby Renee is going to hire Alexa as the CEO of her company. So we've sort of set out who the parties are and what the definitive agreement is that's going to be drafted from it. Sometimes there are multiple definitive agreements that are going to be drafted from it. For example, I can go back to my distribution agreement example. It's, you know, I'm hiring you to be my exclusive distributor in this territory. So there's a distribution agreement that you and I are going to enter into, but I'm also licensing my IP to you so you can use it to market and advertise the product that you're distributing. So we're going to enter into a distribution agreement. We're also going to enter into a licensing agreement. And these are the terms of each of those agreements. So a term sheet is really going to show you the entire sum of what this transaction looks like. And it's going to lay out all the different agreements that you're going to enter into. It could be one, it could be two, it could be, you know, if for some reason, you know, down the line, I have additional products, I'll sign an additional distribution agreement for those products or an amendment. It could lay out the terms of what the parties are going to do in the future. So those are really some of the big things that we talk about when we say, what does the legal structure, legal transaction structure look like? The term, how long is this going to last? How long is our relationship going to be? Is it going to be indefinite? Is it going to be a year, 2 years? Is there a renewal period? If there is a renewal period, are there conditions on that renewal? So we've got the term. And then the payment terms. Who is paying whom? Am I being paid for the use of my IP? And then I'm also paying them to distribute, and I'm paying them for exclusivity of distributing in a particular territory. So which way is the money flowing? How much? When is that being paid? The first of the month, the 15th of the month, quarterly. So we want to like lay that out. Is there an escrow? Am I supposed to be putting in money into an escrow? Sorry, we got a eco-friendly office over here. The lights turn off on me every 15 minutes. So, what are those payment terms looking like? Exclusivity. Are you going to stop negotiations, or I'm requiring you rather, to stop negotiations with anybody else who has a product like mine while we're discussing this agreement, while we're going from term sheet to full-fledged legally binding agreement? You have to stop any discussions with any other customer or potential contracting party that could have a competing business to mine. So you ask for exclusivity in a purchase agreement. The term sheet could say, you can't offer to sell your assets or your business to any other third party so long as we have this term sheet in place and we're moving towards a definitive agreement. And there can be an exclusivity period. And in fact, you should have an exclusivity period, 30 days, 60 days, 90 days, and a provision that extends that. If for some reason you don't get to those definitive agreements within your exclusivity period, you should have a provision that says, exclusivity can be renewed for X amount of days on a written agreement. And so you can extend that. I've extended exclusivity terms in term sheets many times while we're still working towards getting the final definitive documents drafted and signed. Confidentiality is another big thing to include in a term sheet. Do you want your this potential relationship to be kept confidential? Do you not want the other contracting party to tell anybody about what you guys are planning to do, what direction you're moving in? Now, prior to a term sheet, sometimes if you're bringing somebody into your business, potential funding rounds, agreements and transactions where there is diligence involved and sharing of information. Prior to a term sheet, you probably want an NDA, and that's a whole other discussion that we can have at another time. We're not focused on those here, but NDAs will keep your information confidential. Term sheets, confidential provisions will keep the actual transaction. Now, if there is an NDA, I would advise to roll that NDA and name it in the term sheet, that the parties have an NDA, that it's still in full force and effect. So, I would reference that here. Any conditions to close? Is there a financing condition? Is there any other contingency? Like, you have to be able to get the money before you can, invest in the company. Or, for example, I'll go back to my distribution example. I've done a few distribution contracts in the past few weeks, and so that's why it's sort of on top of mind. But, I'm getting a business loan so that I can make more product. And maybe this distribution agreement is contingent on me being approved for that business loan. And so we want to build that in there. We want to make sure that I don't get stuck in an agreement where I can't fulfill my obligations because I don't have the money to do so. So those are some really big major points that we'd find in a term sheet. Also, other deadlines and other terms. Any additional obligations that either of the parties have. Non-competes, non-hires. Now, mind you, there's also another sort of tidbit of information. that's brand new, not something we'll dive into. I'm not employment counsel, but there's a new Valentine's Day rule that says that non-competes are unenforceable in California. So you could take a look into that in certain scenarios. So that's a good little morsel to use. So, and the last thing is, when is this definitive agreement going to be signed? Are we expecting to sign in 60 days, 90 days? What is that? So that we can have an expectation of how long this is going to go. Okay, term sheets. Now that we've talked about the provisions that we find in them, we've talked about why we use them, and now we're going to talk about the fact that they're non-binding. And so then the question becomes, why? Why would we have a term sheet if I can't hold you to the terms that are in the term sheet? So, you know, it lays out a very good foundation of what the agreement is, lays out a very good foundation of the business terms so that everybody is on the same page. It's an evidence that everybody is on the same page. And you typically can refer back to it when you're drafting the full-fledged legally binding agreement and say, well, we agreed to this. And so that's where we're going to, it's a negotiation tool. You agree to this, that's what we're going to do because that's what you agreed to. And that's what we both agreed to. Now, most of the terms are non-binding with the exception of a few provisions that are typically found in term sheets. And that would be confidentiality, exclusivity, and really you can pick out whatever other terms that you want to make binding. But those are really the two provisions that we see a lot. There's usually a paragraph at the bottom that says, the nature of this term sheet is non-binding with the exception of section blah, blah, which is exclusivity, and XYZ, which is confidentiality. So you can have a non-binding term sheet with provisions that are binding. And typically that's what I see. Okay, let's talk about why some of what I just discussed is important. So you know what a term sheet is, what should be included, but we should talk about the why. Hindsight is 20/20, and learning from others' downfalls can really put you in an incredible position of power in your negotiations. You know, so here's the problem presented. A contracting party can use almost any excuse for renegotiation of the terms of a contract after a term sheet has been signed. So as a business owner, you're typically the one to present the opportunity to the investor, to the potential partner, to other operators that you'd like to contract with. You have the ability to control the pen first. Use it. Use it to your advantage. You want to memorialize everything that you possibly can in this term sheet that's important to you. If it's important, it should be in the term sheet from the very beginning. I'll give you a story of a client of mine. This was a purchase agreement. My client was selling their business and a license to a third-party buyer. And towards the end of the negotiations, the buyer said, well, you know, we're waiting on a loan, and we'd really like to build in here that the loan fund before we close and fund the purchase. And I went back to look at the term sheet to make sure I didn't miss anything. And at no point was there ever a funding contingency discussed in the term sheet. Nowhere. I had never heard about it. My client, this was the first time they had heard about it. If this was something important, things like this can make or break deals. And so you want to make sure that all the important factors are built into the term sheet, that the other party knows exactly the position you are in, that there are no surprises down the line, because things like that can kill deals and you'll have a dead deal on your hands. And now you've spent all of this money going through a term sheet, negotiating the purchase agreement or whatever agreement that we're drafting the agreement. Now you're thousands of dollars in over your head and buyer throws this at you. And you're not going to sign the agreement because this is what buyer wants and they've dug their heels into the ground. So you really want to make sure that you have open, honest, detailed discussions at a term sheet phase to make sure that you have covered everything that you possibly could have and put everything that is important to you and to the other contracting party in this term sheet, because you do not want to find yourself at the end of the rope and nothing to show for it. So that's my first sort of lesson. Next one, problems and solutions. Problem. The longer the exclusivity period, the lower your negotiating leverage. Most exclusivity periods range from 1 to 3 months. Our solution is to keep the exclusivity period short and include certain milestones. So the second that the parties are locked into exclusivity, they know they've got you because you cannot go anywhere else to offer this transaction to someone else. So if I'm selling a portion of my business to a third party and they've locked me into exclusivity in the term sheet for 5 months, they know they have 5 months to figure out how they want to do it. And if they're operating or negotiating in bad faith, they'll take that full 5 months to maybe yank your chain around a little bit. And then, they know that they can ask for sort of outlandish things because you can't go anywhere. You can't say, you know what, I'm done. I don't want to have these conversations with you anymore. You're taking full advantage of me. I want out. Because you're under exclusivity. And even if they do let you out, you still have to wait for that exclusivity period to expire. So you want to keep them short and you want to have the ability to renew them. So that's a little bit of like an operating pro tip as to when you're in a term sheet negotiation, sort of what that looks like. And so that concludes our discussion on term sheets, the sort of broad why, what, how they work. And we're going to move on to operating agreements. Okay, operating agreements. Now we're going to the why and the what. So let me first tell you what an operating agreement is. When you form an LLC, a limited liability company, there are governing documents that kind of give you the playbook. So it's like a club. Your company is a club. What are the rules of the club? That's your operating agreement. We wear pink on Wednesdays. We drink smoothies on Fridays. The general sort of what are the rules of the club. And for those of you who might have a corporation, in the corporate world, corporations have shareholders agreements, which are the same as operating agreements. So if you have an LLC, you have an operating agreement. If you have a corporation, you have a shareholders agreement. They are both similar documents in different realms, governed by different statutes, but they ultimately do the same thing. So if you're an LLC, you don't have a shareholders agreement, you have an operating agreement. So an operating agreement pretty much defines the business's financial and functional decisions, the roles, the responsibilities, the liabilities, and it establishes how the decisions are made, how profits are shared, and how members will be paid. What are the distributions? How can I sell my interest? What can I do with it? How do I vote? How much of a vote do I get? All of those sorts of things. So why should you have an operating agreement? The members have agreed upon rules and procedures that they can refer to in the event of conflict. If you and your partners have an issue as to how to determine a corporate decision, refer to the operating agreement. It literally lays out your directions and your instructions as to what you need to be doing in the event of that conflict. And it prevents you from being at the mercy of state statutes, which can be vague and confusing and may not do justice for the intention of the members. Because there's a statute that governs LLCs in California, it's the LLCA, you want to make sure that you've created your own rules. Otherwise, if there is no rule that governs whatever conflict you have, whatever issue you're trying to resolve, you've got to look to the LLCA, and that'll tell you what to do. And sometimes it's very helpful, but other times it could be an expensive solution. It could be a complicated or a difficult solution. So you want to make sure that you lay it all out in your operating agreement. Another sort of housekeeping matter for operating agreements and LLCs in particular. Another dichotomy of corporations and LLCs is corporations have shareholders, and shares are where you own your equity. In LLCs, you're not a shareholder, you're a member of the LLC, and you own interest or units. So they're, again, different terms for the same concept. So in an LLC, you are a member and you own units and you have an operating agreement. So those are sort of the general LLC terms and lingo that you should have in your back pocket. Okay, how is your LLC managed? So now you've determined you're going to draft an LLC, draft an operating agreement, and how are you going to manage it? So the way that I look at the difference between an LLC and a corporation is, bear with me, an iPhone and a Samsung. So an iPhone sort of has this like set up structure for you. There are certain customizations that you can make, but there's only a certain extent to what you can do. You can't change the font on your phone. You can make it bigger or smaller, but you can't make, Times New Roman or Cosmic Sans or whatever that is. You can't change the different colors of the writing. There are certain things that you can't do, but there is customization that you can create. That's a corporation. There's these like structured bounds that you have to stay in. With an LLC, it's more like a Samsung phone. You can change the font, you can change the color. It's a little bit more highly customizable. It gives you a little bit more leeway. And that's what LLCs do. They're a little bit more sort of flowy. You can create and have the freedom to be more flexible in an LLC. They don't necessarily have officers or a board of directors. They have managers. Again, another term as opposed to a corporation that has the board of directors. LLCs have managers. And so you can choose at the outset of your entity, the filing of your entity, whether you're going to be member managed or manager managed. And what that means is, are you going to have managers that are making the decisions, the high corporate decisions, or are all the members going to be making those decisions? And you have to have a vote of all the members. Or is it just the vote of the managers? And so you get to figure out and just think about how you want your LLC to be structured. And that's going to drive how you draft your operating agreement, whether you are manager managed or member managed. So we're back to an operating agreement. What is in an operating agreement? So you lay out the basics. What's your name? What's your company name? What's your address? Who's your agent for service of process? The names and address of each member, each owner of the LLC, the amount of capital contribution that they made. So how much did they pay to get their equity? The classes of units. This is a nice thing about LLCs and their flexibility. is you can create all these different classes of units, and you can have members in each different class, and each different class can be treated differently. Each different class can have different voting ability. Each different class can have different distribution waterfalls. You can really sort of customize it. And that's sort of what I was talking about with the flexibility of an LLC. And lastly, how can members transfer their equity? You know, I've got this ownership. Can I sell it to a third party? Can I give it to my brother? Can I put it into my trust for estate planning purposes? What can I do with it, and how can I sort of function with my equity? You know, entities like this that are not publicly traded, you can't sell it on the open market like you can a stock that you trade on the NASDAQ or S&P. It's a little bit of a different. So there's the operating agreement will tell you how you can get rid of your equity, who you can sell it to, when you can sell it, what are the rules around it, those sorts of things. Then you also want to lay out your tax treatment. I am not a tax attorney. I don't pretend to be one. I don't play one on TV, but I know enough to be dangerous, and I know enough to tell you that you should always, always, always contact and consult with a tax attorney about the tax provisions in your operating agreement. The one thing that is very beneficial about an LLC is that you can choose how you're taxed. You want to be taxed as a corporation, as an S corp, a partnership. It really sort of depends, and you should have that conversation with your CPA or your tax attorney to make sure that your LLC is being treated with the most beneficial tax treatment. Okay, moving on to distribution of profits and authority. So how do you distribute profits to members? Typically in an LLC agreement, if it's manager managed, the manager will have the ability to make the decision if distributions are going to be made and when they're going to be made. And usually there's what we call a distribution waterfall. Who gets paid first? Who gets paid second? How much each of them is being paid? Sometimes, you know, there will be provisions that say, you know, these loans need to be paid off first. Thereafter, those individuals, if you have different classes of Unit A members are being paid, 70% of the distribution amount. The remaining is going to Class B members, pari passu, meaning in there to the extent that they own that certain percentage. So you can create a waterfall of how much people are getting paid and in what order, and how the money that's being determined to be distributed, how that's going to be sort of laid out between all of the members. And you've got the freedom to kind of play with that. The waterfall is oftentimes a highly negotiated provision in an operating agreement to determine, especially if you have investors and you have a lot of other partners in your LLC, understanding and making sure that everybody knows how they're going to be paid and in what order, is important, because that's their ROI. That's the only reason, well, maybe not the only, but a big reason of why they are part of this LLC, to get paid. If you are a manager of an LLC, you get to define the scope of authority. What can the manager do without requiring a member consent? Founding members and managers should have the broadest scope of authority. So, for example, let's just stick in the realm of manager-managed LLCs. You can decide that the members have zero voting power, and the entire company is to be run by the managers. And you can do that. You can make sure, even if you have multiple classes, none of the members, no matter what class, can vote on anything. I will caution you that the LLCA does require members, no matter how your operating agreement is set up, does require members to vote on 4 things. It's mandatory. An amendment to the operating agreement or the articles of organization, the admission of a new member, a merger, or a dissolution of the company. Those 4 voting rights you cannot take away from members. Everything else you can put in the hands of a manager. If you decide that you want the manager to make all of these decisions, but if you're going to take a loan, you want the members to be able to decide. So you can pick and choose. And often in an operating agreement, there is a list of the decisions that a manager can make and a list of decisions that members can make. And sometimes the decisions that members make still have to be approved by a manager. And you can create that. That's part of the flexibility of an LLC. You can also determine that if you've got different classes of units, Class A members can vote on these types of things. Class B members can only vote on these types of matters. So you can really customize it as to who has what voice and what approval is required. So maybe the members are required, you have to get a member vote if you're going to take out a loan over $500,000. But what's required for that member approval? Is it unanimity? Do all the members have to say yes? Is it a supermajority? Maybe only 75% of the members have to say yes? Is it just a majority, 51%? So you can determine that as well. What is a consenting vote? And you can make different votes have different requirements for approval. If you're admitting an additional member to the LLC, maybe that requires unanimity. All the members have to vote to approve this new member coming into the LLC. But if you're taking a loan, you only need 50% of the members to agree. So you've got all this sort of customization, which I know it's a lot to think about. Usually when I incorporate for a client and we're starting to talk about drafting an operating agreement, I give them a 7-page questionnaire to ask them all about these questions and how they want their company to be run. And we usually spend 2 or 3 hours going through that questionnaire and talking about what provisions they want to make, how they want the votes to be, approval ratings and stuff like that. And then we talk about what that actually looks like in application. And then again, transfers of your ownership. Now you own a unit or units in this LLC. What good is it going to do for you if you can't make it liquid if you need to be, or if you want to transfer it for estate planning purposes? So usually LLC agreements, operating agreements, have a provision that is called a permitted transfer. And usually transfers in general are required to be either voted on members or approved by managers, however you've sort of laid it out. But usually there's an approval process, because when you go into business with, let's say, 4 of your friends, and each of you own 25% of this LLC, I bet you part of the reason that you own your 1/4 of ownership in this company is because you wanted to go into business with the other 3. And that's who you wanted to partner with. But if one of the other 3 decides they want to sell their ownership to Joe Smith, that wasn't what you signed up for. You didn't want to be in business with Joe Smith. You want to be in business with this particular partner. And so there's requirements typically when you're selling to a third party. However, in LLC operating agreements, there is typically a section that is called permitted transfers, where you don't need the members or the managers to approve your transfer. And those are typically for estate planning purposes, when you transfer your ownership either from you as an individual to your trust, or from you as an individual to another entity that you either control or have majority control over, those should be permitted transfers, and you should be allowed to do those because the partner isn't changing necessarily. You are still the owner of that equity. It's just being held by a different form or indirectly through an entity. And then the not permitted transfers. And those are the third party transfers where usually the companies need to have a conversation about, the members rather have to have a conversation about who is this? Are you going to offer your other members the right of first refusal? So if I want to sell my ownership to Joe Smith, do I have to offer it to my other 3 partners first? And they get a first bite at the apple before I can take it to the open market. What is that price going to look like? How are we going to evaluate that? So those are a lot of the understandings and the major points of an operating agreement, what you want to see, how you should be drafting these, the considerations of the thought process of what you should probably go through with your partners when you're drafting your operating agreement. And that concludes my discussion on operating agreements and term sheets. I know I shoved a lot into an hour and I didn't leave a whole lot of time left for questions, but I saw the time, so I tried to speed myself up. But what do we have?
Yeah, any quick questions? I did answer one that popped up. I took the liberty. Someone was saying, when would you, at what point would you do a term sheet? And I responded that usually, at least in early stage investing, the investors give you the term sheet,
Yes.
not vice versa. So it would be unusual. I do see companies from time to time putting a term sheet out. Most investors don't really like that. They feel like it's kind of
It's their
presumptuous.
money, their rules.
Yeah,
Yes,
exactly.
very much so.
Exactly.
When you're dealing with funding and investors, it's their money, their rules. And you're in a position where sometimes you don't really have a choice. You need the capital, you need the influx, and so your bargaining power there is a little diminished. But in other contracting scenarios that you would have a term sheet in, typically the company will draft the first one.
So, one question that comes up a lot, I get asked all the time, is LLC versus corporation. And I'm not sure if you answered that in there. Maybe I missed it. I saw you had the tax designation, but you were focused on LLCs. And so I'm going to just preempt and throw that one out there for you.
Absolutely. I think that the question really is a question of tax, LLC or C Corp. But I think a secondary consideration after sort of the tax treatment and the thought process there is, what are your goals for the company? What direction are you moving? How flexible do you want to make it? Are there going to be, different, are you going to be building an investor pool? If it's sort of like a family-owned, family-held company, an LLC might be best for you because it gives you flexibility. It gives you, sort of the ability to run it the way that you want. Corporations are more structured. They've got, they're statute driven, and they have these sort of very rigid parameters in which you need to stay in. A lot of my clients are LLCs. I don't have a ton of clients that are corporations, and if they are corporations, they were incorporated before I was born.
That's actually really interesting, Alexa, because a lot of there are a lot of investors who can't invest in an LLC. So most startups, I say, start as an LLC, but have to convert to a C Corp, once they do a real round.
Yeah, I see that a lot too. I
Yeah.
absolutely see that a lot too.
Yeah, because the investors don't want to have to wait on K1s and deal with, the potential for UBTI. So
Yeah,
that's
which goes back to the discussion about tax and
yes.
through.
Right.
So that's really a big consideration to take in. Your tax attorney is going to be a very good resource for a discussion of
Yeah.
LLC versus C Corp.
Yeah, exactly. So let's see, there was a question. Yeah, I think we've answered most of these. Yeah, we've got someone was asking for your email address, and someone also asked about samples of agreements, and I did put in there NVCA. So for those of you who are startups, the National Venture Capital Association has a lot of what they call model agreements on their website that you can look at and see what standard terms are. And a lot of people just rely on those terms these days. I don't know if you have any other suggestions, Alexa, but that's kind of where I would push people.
That would exactly be my suggestion.
Yeah. So can you put again the agreement? I'm sorry, can you put, NVCA, National Venture Capital Association, NVCA. I think it's nvca.org, actually. I'm not sure. So, all right. Well, Alexa has a hard stop at the top of the hour, and as we only have 1 minute, I am going to suggest that we break. And as I mentioned, this was recorded. It should be posted tomorrow, and we will also have a PDF for you of Alexa's slides. And and you have her contact information. Again, encourage you all with startups to consider applying to our fast pitch, and hope to see you at future sessions. And if you've missed any of the prior sessions, those are also available. So Alexa, thank you so much. That was really informative and helpful, and I'm sure people got a lot of great tips from that. So thank you so much.
Thank
And
you for having me. It was a pleasure.
Yeah, pleasure to have you. Great. Thank you.
Thank you. Take care, everybody.
Bye.
Bye.